Imagine you're a justice on the United States Supreme Court in the mid-1930s. The Great Depression is raging. Both the states and federal government have enacted significant economic regulations in the attempt to bring order to the growing economic chaos. But looming in the legal background is the court's 1905 decision in Lochner v. New York, which held that the government violates the freedom of contract, a component of due process, by regulating working and employment conditions. To make things worse, the President and many in Congress have threatened to secure legislation expanding the number of justices on the court from 9 to as many as 15 to allow it to overrule Lochner and permit the states and federal government to enact new economic and employment regulations. The court faced these difficult circumstances in 1937 when it decided West Coast Hotel Company versus Parrish. From 1933 until 1935, when she was fired, Elsie Parrish worked as a hotel maid in Washington. Her employer, the West Coast Hotel Company, had refused to pay her the minimum wage required by state law for female workers. After being fired, she filed a lawsuit in state court demanding the difference between what she had been paid and the minimum that she was due under state law. The trial court held that the state law violated the Due Process Clause of the 14th Amendment because it infringed on the liberty of contract between an employer and employee. On Parrish's appeal, the Washington Supreme Court reversed the trial court. The West Coast Hotel Company appealed to the United States Supreme Court.